Today's topic is Title 4D Welfare Services. I'm going to answer two questions in the next hour and a half, and those questions are, first of all, does the federal government allow the state to initiate reform and clarify eligibility standards for Title 4D welfare services? The second question, will state legislators be assured the state won't lose the entire federal funding for 4A and 4D as the state DHS alleges? As we go through those two questions, the first question, I will review the outline listed here. We'll review family law versus welfare law, public rights versus private rights, the history and purpose of 4D as it is in the Social Security Act, the limitations of Title IV, Title 4D amendments, the unauthorized expansion of the 4D program, outcomes that produces regarding process and fiscal outcomes, and then we'll talk about the constitutional violations created as a result of that overreach. The second question I'll review and outline that will answer and describe for you the CPR solution, what the DHS claims, what the misrepresentative federal penalties are, what they look like, the positive impact that change and reform would have on government budgets, and also, hopefully, we'll have some time to discuss some fiscally responsible decisions that we can work with together. I want to begin with a disclaimer and make sure that you know that I am not an attorney and nothing I say today should be in any way, shape, or form considered legal advice. Though we have run through all of our information by our advisory board attorneys, several people who were able to work with and give us that legal input. I have also received information from 3 judges, 2 retired district court judges in Minnesota, 1 retired appeals court judge in Minnesota that believes that our information is accurate, and we continue to expand that base of interested judges and lawyers, although I found that retired judges are more willing to talk to us. The first question, does the federal government allow the state to initiate reform and clarify eligibility standards for 4D welfare services? The first subject in that area is family law versus welfare law. At the legislature, you've heard a smorgasbord of family law issues. There's child support legislation that Senator Neville has done an incredible job working with, which mostly focuses on the guidelines, whether it's a net income, income shares, cost shares, whatever it is. Then there's been legislation on joint physical custody. There's been legislation repeatedly year after move-aways, and really many other family law related issues, things as like OFPs, parenting plans, imputed income, a host of different topics that affect family law or that are part of family law. And last but not least on this list, of course, is Title 4D welfare reform. And I put this slide up here on purpose to show you that Title 4D welfare reform is different. It's something separate from all of these other issues, so it does not need to be in conflict or worrisome with any of the other legislation that we do also get involved in. I want to begin by saying also that we at CPR believe that both parents have an equal duty to support their children. And nothing that we are promoting or nothing that we are suggesting in Title 4D reform will at all impact that philosophy that both parents do have an equal duty to support their children. Title 4D is the child support enforcement and collection program put together by the federal government. So it's a federal program that's state supervised and county implemented. You're familiar with those kinds of programs. The Title 4D welfare program causes some problems or causes some myths. It's based on some presumptions that carry through the whole implementation of 4D, which causes concerns for us, and I'll go through a few of them here. The Title 4D system is premised on the assumption that moms have custody, and I'll go through later why that is. The 4D system is based on the belief that women are unable to self-sustain. The 4D system is based on the myth that dads don't want a parent and are only minimally involved with their children. And the 4D system is contingent on the fact that one parent is labeled an absent parent. The 4D system is based on the erroneous belief that dads won't support their children unless they're forced to pay. In fact, in the early 1970s, when they were looking at the 4D program for the first time, the National Organization of Women testified before Congress regarding why these child support laws were needed. And they testified saying that because they were getting, just by default, having custody of all these children, they made it clear to Congress that their views at that time were custody of the children to the mother is not an award, it's a sentence. That's why they created the 4D program at the federal government, to try to rescue these women from the burden of custody. The other premises or myths or basis of the 4D system include those that are on here. What it does and the problems it creates is it builds a huge bureaucracy that supports one parent at the expense of the other. It gives the custodial parent a sense of invulnerability because they have this whole bureaucracy on their side. It creates increased animosity between parents, pitting one against the other, driving a further wedge because you've got that whole system that's constantly initiating actions that the custodial parent hasn't even initiated themselves. This creates a deeper conflict, and conflict is what's worse on kids. Conflict is worse on kids than divorce itself. And the 4D system then is based on the concept that the custodial parent will get everything, because remember, and you'll learn as we go through the presentation, that the assumption is the dad's not around. The 4D system, because it provides all these things for the custodial mom, provides everything for the custodial mom, and I say mom or dad, if I say those words erroneously through my presentation, there are non-custodial moms and there are custodial dads. But sometimes I slip up and use gender-based language, mom and dad, and that's only because, according to the University of Minnesota, 90% of the divorces and paternity cases in Minnesota result in custodial mom. So forgive me if I use those a little too loosely at times. The 4D system, probably the worst thing, and why there's so much of an uproar on this, is the sense of fairness is absent in the 4D system because the power of equities are not used in administrative law. And all these proceedings are done in administrative hearing process.